Germany on November 20th, 1945. The defendants were 22 of Adolf Hitler's top Nazi leaders, described by international prosecutors as living symbols of racial hatred, terrorism, violence, and the arrogance of cruelty and power. The International Military Tribunal, or simply Nuremberg, as it has come to be known, was convened not just to condemn and punish, but to establish the idea that from that point on, the world would hold those who committed such acts accountable. Those who brought the charges said our civilization could not survive if such horrors were repeated. Today, as we hear and read about the terror in Bosnia and other parts of the world, we can't help but hope that the lesson of Nuremberg has not been forgotten. Court TV's presentation of the Nuremberg Trial should remind us that history can be and should be our greatest teacher.
Welcome back to Court TV. I'm Ricky Kleeman. As we approach the final period of the 20th century, we can look back some 50 years and truly see its greatest trial of the crimes committed by the Nazis under the messianic leadership of Adolf Hitler. After the Second World War, Nuremberg became the site of a 10-month trial against 22 men, one of them in absentia, in an effort to expose the horrors of the Nazi regime and to attempt to deter such unspeakable conduct in a civilized society in the future. 4 nations cooperated in this historic occurrence. There were prosecutors and judges from the United States, Great Britain, France, and the Soviet Union. The United States prosecution wanted to use this forum to create a new international law. Terry Moran takes us back to the end of the war and the beginning of the International Military Tribunal.
This time it's the German army that surrenders. No civilians are involved as in World War I. This time the Wehrmacht takes its full share of blame for years of ruin and brutality.
The end of the Second World War in Europe marked a military triumph purchased at a harrowing cost.
All Nazi government buildings have been destroyed, burying the infamous Hitler and Goebbels in their rubble.
A continent lay in ruins. The great cities of the old world had been pounded into rubble.
This was the Belgian cathedral city of Louvain. Night after night, London was left a sea of fire. This was Rouen.
30 million refugees wandered through a nightmare landscape. Famine, disease, and desperation stalked the land. But more than just the physical and economic infrastructure of Europe needed to be rebuilt. The victorious Allies decided that to make a true peace, justice must be sought. Justice for an almost unimaginable crime.
Dachau, factory of horrors. Incoming prison trains arrived, carrying more dead than living. This is how they looked when they arrived.
Today, Dachau is a museum. Its horrors safely interred in history. But what happened here, just 12 miles outside of cheerful, beery Munich, and what happened at the hundreds of other death camps throughout Nazi-occupied Europe, shocked the world into action. This time, however, no shots were fired in retaliation, no bombs dropped. Instead, law was the chosen weapon of the triumphant powers.
The tribunal will now enter.
A court, an international military tribunal, was established to investigate, prosecute, try, and punish the surviving leaders responsible for the atrocities of the Nazi regime.
The indictment shall now be read.
The idea of trying the top Nazis grew out of the culture and history of the Allied powers. Sir Hartley Shawcross was the chief British prosecutor at the Nuremberg trial.
I thought the prosecution was very fairly conducted, really, according to what one might say without boasting, the best English tradition. And the English tradition in criminal work is very high.
The case was controversial. Revenge was the only kind of justice many people wanted. Prime Minister Winston Churchill of Britain supported summary executions of the Nazis responsible for making the war and running the camps. Everyone connected with it, Churchill wired his foreign secretary in July 1944, will be hunted down and put to death. But the British were overruled, and the court was established at a German city full of symbolic meaning, Nuremberg.
Largely for psychological reasons, that it had been the leading establishment of the Nazi parties. They were based essentially on Nuremberg. There was a courthouse there and all the facilities for a major trial.
Nuremberg in the 1930s was the showplace of Nazi grandeur, the setting for enormous, garish displays of party discipline and determination.
Es spricht der Führer.
But the war brought ruin to Nuremberg. The city was destroyed. Out of the ashes rose the ideal of the Nuremberg Trial. War must come under law.
The privilege of opening the first trial in history for crimes against the peace of the world imposes a grave responsibility.
A special charter laid out the ground rules for the new court located here in courtroom 600 of Nuremberg's Palace of Justice. And it was here, 5 months after the German surrender, that the international prosecutors issued their indictments. Their charges were broad, bold, and uncompromising.
The swastika will no longer flaunt its crooked arms above the Nazi shrine.
24 Nazi leaders, military officials, and industrialists were accused under 4 broad headings. Count 1 covered the formulation or execution of a common plan or conspiracy to wage aggressive war. Count 2, crimes against peace, dealt with the actual making of war in violation of treaties. Count 3 covered war crimes, and Count 4, crimes against humanity. To the defendants, these charges and the entire prosecution were bogus, nothing more than victor's justice. Otto Kranzbühler represented Nuremberg defendant Grand Admiral Karl Dönitz.
That whole business was aggressive war, was fabricated.
Did you have vengeance in your heart because of that?
Well, I think I'm too experienced a criminal lawyer and prosecutor to be affected by feelings of vengeance. I don't think I had any such feeling at all. I may well have thought when they were sentenced, well, they deserved it.
But beyond the courtroom drama and political debates, the silent testimony of Nazi Germany's millions of innocent victims overshadowed every day's proceedings. Their suffering cried out for justice in November 1945, and it haunts us still.
Joining us for this 3-hour segment this evening is Alan Dershowitz. Alan is here for his first visit at Court TV. You are someone that most of the country knows for a variety of reasons, but I think I'd like to tell our viewers some things they may not know about you. You graduated from the Yale Law School in 1962, magna cum laude. You went on in parts of your work to become a professor at the Harvard Law School. As I recall, you were the youngest full-time professor ever appointed there. You have written countless articles, both in legal publications, magazines, newspapers. But some interesting facts about you that even I didn't know, and I have known you myself personally many years. You've been on the advisory board of the International Parliament Group for Human Rights in the Soviet Union. And you formerly were on the National Board of Directors of the Civil Liberties Union. You've served 3 times on presidents, that is the United States presidents, various commissions, including civil disorders, drug abuse. You've been a member all the way back some 20 or so years ago of the U.S. debate team, when 1977 going over to debate the Soviet Union on human rights. And in terms of Nuremberg, your presence here is especially appreciated by all of us at Court TV because you have a special affinity for Nuremberg. You have assisted in a book in writing prosecution of Nazi war criminals, co-authored a book with prosecutor Telford Taylor, and used the Nuremberg principles in the defense of certain defendants. And we're going to get to talk about all these things as this 3-hour segment goes on. I give you a sincere welcome from all of us.
Thank you so much, Ricky. This is really an important public service that Court TV is doing by presenting these trials.
Thank you. Well, during our coverage, we will bring you the reflections of some of the people who were at the Nuremberg trial. And as you'll see, the trial evoked many different and powerful reactions.
We picked those whom we thought had played the leading part in leading the Nazi Party along the path it took.
It nearly seems impossible that some top people didn't know. You mentioned Göring, Kaltenbrunner, I should say, but it's just guessing. There has been no proof.
I felt that I would gladly shoot them myself if I had an opportunity. If I could get close enough, I'd garrote them or cut their throats or something.
As I saw them coming in there, I could hardly really believe it's finally happening. And I must say, tears came to my eyes.
That was Drexel Sprecher, a U.S. prosecutor at Nuremberg, displaying emotion shared by many who had fought the Germans at war and then tried to fight them fairly in a court of law. Those accused of war crimes were chosen as representatives of the major administrative branches of the Third Reich and included prisoners held by each of the 4 prosecuting nations. Attention was paid to how well known they were and how much power they exercised. But sometimes the most notorious were dead or missing, and a player far lower in the hierarchy was substituted. Looking at them in court made one wonder how these men wield such extraordinary power over so many. At times they looked puzzled, even confused, as they sat in the left front area of the courtroom known as the dock, with military police standing guard behind them and the bright lights for the film camera shining into their eyes. The Nuremberg defendants looked too insignificant to have committed the crimes for which they were on trial. Yes, they were some of Germany's top Nazi leaders, but what were their jobs under Adolf Hitler?
Today, the rebuilt German National Guard rises again on the strong foundation of the National Socialistic ideology.
Some of the defendants, like the rotund Hermann Göring and the intense Rudolf Hess, were especially familiar to the public at large, thanks to Hitler's propaganda machine and the international newsreels of the time. Göring was the commander-in-chief of the Luftwaffe, Germany's air force, and chief of war economy. Until he changed his mind at the end of his reign, Hitler proclaimed Göring as his successor.
You shall give in unison the oath of fidelity and obedience to Adolf Hitler.
Hess, the deputy to Hitler for Nazi party matters, had been the third-ranking Nazi in Germany, one of a handful of old party fighters. Hess flew to Scotland in 1941 with a secret handwritten peace proposal for the British. When he learned of Hess's flight, Hitler denounced his old friend as having a mental disorder. Hess spent the war in a British jail.
Name, please.
Another defendant, the polished Albert Speer, was viewed by some as Hitler's most trusted confidant. The men shared a love of art and both viewed themselves as creative spirits. Speer first served as the Führer's chief architect and then headed up German munitions production during the war. To produce those weapons, Speer needed workers. To get them, he turned to defendant Fritz Sauckel, the Nazi responsible for slave labor during the war. Sauckel often said he just rounded up the workers and was not responsible for their treatment. The scar-faced and menacing Ernst Kaltenbrunner was accused of implementing the Jewish death campaign. As head of the Gestapo and overseer of the concentration camps, Kaltenbrunner, a lawyer, was said to have bragged about his quota to kill 1,000 Jews a day. Among Hitler's top military men indicted at Nuremberg, Karl Dönitz, commander of the German Navy and successor to Hitler, Wilhelm Keitel, head of the German High Command who signed Germany's surrender in 1945, and Alfred Jodl, operations chief of the German Armed Forces. Not all of the defendants gave orders or speeches. Some were instrumental in raising money for the Hitler reign. Banker Halmer Horace Greeley Schacht spent his youth in America with German immigrant parents. After the family moved back to Germany, Schacht became president of the Reichsbank, Germany's state bank, then minister of the German economy. Schacht's successor at the Reichsbank, Walter Funk, was also in the dock. Funk was accused of knowing the source of Nazi loot, including heaps of jewelry and gold teeth that had been recovered from the vaults of the Reichsbank. It was a horrifying treasure trove from the Jewish concentration camps that would hover over Funk and the rest of the men on trial at Nuremberg. How much each man knew about the killings of millions of military and civilian prisoners would become the question that haunted the trial. I'm here with Alan Dershowitz, and Alan, if I may call you that.
Please.
Was this a legal trial that is based in law? Was it a show trial?
A little of both. For the United States and for Britain, it was really a legal trial. It was an attempt to bring the common law, which is the great heritage of the United States and Britain, into international law, to try to develop a common law of human rights, a common law of crimes against humanity. For the Soviet Union, it was a show trial. It was simply one of many show trials that were going on at the same time. There were show trials in Czechoslovakia. There were show trials in the Soviet Union itself. It was an attempt to blame, for example, the Germans for what they themselves had done in the Katyn forest by killing many of the leaders of the Polish army and intelligentsia. So it served many, many purposes. And its legacy is primarily a legacy of the United States and Britain. We succeeded. We established principles of international law, not always abided by, but widely recognized among the nations as currently applicable, and lawyers have used the Nuremberg principles both to prosecute and to defend. So it was very much a worthwhile, though somewhat flawed endeavor. It couldn't be perfect because it was political in nature as well.
We're going to talk more about some of those issues as we go on through this evening. On November 20th, 1945, the president of the court, Sir Geoffrey Lawrence, begins with a statement listing the 4 counts of the indictment. Number 1, crimes against peace or waging aggressive war. 2, war crimes. 3, crimes against humanity. And 4, the conspiracy to commit these crimes. He requests one of the United States prosecutors, Cindy Alderman, to begin reading the indictment, a reading which actually took 1.5 days. The indictment arose from a London agreement of August 8, 1945, which created the London Charter that created the court, its rules of law and procedure. The trial as it begins and as it airs this week from 5 to 8 p.m. Eastern Time was filmed in short sections by the U.S. Army Signal Corps. We've edited the film together with sections of the audio tape record. Where only the audio exists, we're using freeze frames of the film shot in the courtroom. The court was called to order.
The tribunal will now enter.
Before the defendants in this case are called upon to make their pleas to the indictment which has been lodged against them and in which they are charged with crimes against peace, war crimes, and crimes against humanity, and of a common plan or conspiracy to commit those crimes, it is the wish of the tribunal that I should make a very brief statement on behalf of the tribunal. All the defendants are represented by counsel. In almost all cases, the counsel appearing for the defendants have been chosen by the defendants themselves. But in cases where counsel could not be obtained, the tribunal has itself selected suitable counsel agreeable to the defendants. The tribunal has heard with great satisfaction of the steps which have been taken by the chief prosecutors to make available to defending counsel the numerous documents upon which the prosecution relies, with the aim of giving to the defendants every possibility for a just defense. The trial which is now about to begin is unique in the history of the jurisprudence of the world, and it is of supreme importance to millions of people all over the globe. For these reasons, there is laid upon everybody who takes any part in this trial a solemn responsibility to discharge their duties without fear or favor, in accordance with the sacred principles of law and justice. It only remains for me to direct, in accordance with the provisions of the Charter, that the indictment shall now be read.
May it please the tribunal, the United States of America, the French Republic, the United Kingdom of Great Britain and Northern Ireland, and the Union of Soviet Socialist Republics, by the undersigned Robert H. Jackson, Francois de Menton, Hartley Shawcross, and R.A. Rudenko, duly appointed to represent their respective governments in the investigation of the charges against and the prosecution of the major war criminals, pursuant to the Agreement of London dated 8th August 1945, and the charter of this tribunal annexed thereto, hereby accuse as guilty, in the respects hereinafter set forth, of crimes against peace, war crimes, and crimes against humanity, and of a common plan or conspiracy to commit those crimes, all as defined in the charter of the tribunal, and accordingly name as defendants in this cause and as indicted on the counts hereinafter set out Hermann Wilhelm Goering, Rudolf Hess, Joachim von Ribbentrop, Robert Lai, Wilhelm Keitel, Ernst Kaltenbrunner, Alfred Rosenberg, Hans Frank, Wilhelm Frick, Julius Streicher, Walter Funk, Halmar Schacht, Gustav Krupp von Bohlen und Halbach, Karl Dönitz, Erich Raeder, Baldur von Schirach, Fritz Saukel, Alfred Jodl, Martin Bormann, Franz von Papen, Arthur Seyss-Inquart, Albert Speer, Konstantin von Neurath, and Hans Fritsche. Individually, and as members of any group of the groups or organizations next hereinafter named.
Up next, the indictments against the Nazi organizations. Here, British prosecutor Sir Hartley Shawcross gives his reaction to the Nazis charged with war crimes.
I think I thought they looked very ordinary people. Goering stood out as obviously a man of ability who would stand out in any crowd. The others, I think, aroused no interest of that kind. They were just ordinary people.
In addition to people, the indictment charged 6 Nazi organizations. These bodies were named to cast a net over their many members. If the organization were found criminal, then a hearing could be held to determine the degree of guilt of a particular member. In American jurisprudence, a fundamental question is raised about the legitimacy of guilt by association.
Die Reichsregierung Reich Cabinet, das Korps der politischen Leiter der nationalsozialistischen Deutschen Arbeiterpartei, Leadership Corps of the Nazi Party, die Schutzstaffeln der nationalsozialistischen Deutschen Arbeiterpartei, commonly known as the SS, and including the Staatspolizei, I beg your pardon, and including the Sicherheitsdienst, commonly known as the SD, die Geheime Staatspolizei, Secret State Police, commonly known as the Gestapo, die Sturmabteilungen der NSDAP, commonly known as the SA, and the General Staff and the High Command of the German Armed Forces.
Organizations, Alan Dershowitz, what about that?
Well, it was an interesting theory. I mean, now that we're familiar with RICO and conspiracy laws, it makes sense. An American lawyer came up with this, essentially, and tried to do a wholesale indictment of organizations so that later, by retail, they could go after individuals in the organization and either prosecute them or denazify them in some way. It failed. It failed terribly. Because the one major moral failure of Nuremberg is by focusing so much attention on 22 leaders and then a few hundred later, it gave the German people, most of whom were deeply involved in Nazism and most of whom supported the programs of Nazism, an out. They were able to say the Germans weren't at fault. Only a few Nazis really were at fault. So among the great gains of the Nuremberg trial, that was one very significant failure. And it played into the Cold War beautifully because it allowed us to say they have denazified those 22. Most of them are now dead. The others have been punished a little bit. Now let's get on with business as usual, making peace with Germany because we're warring with the Soviet Union.
And in the end, politics control the day. Well, British prosecutor Sir David Maxwell-Fyfe reads now from count 2, which is going to be handled by his country's prosecution team. The defendants are charged with crimes against peace or waging aggressive war in violation of law and treaties. It's worthy to note that the United States, in its push for this trial, primarily wanted to create new international law that would outlaw such behavior. This count was the primary thrust of the trial, though not the one that was remembered.
All the defendants, with divers other persons, during a period of years preceding 8th May 1945, participated in the planning, preparation, initiation, and waging of wars of aggression, which were also wars in violation of international treaties, agreements, and assurances. Section 6. Particulars of the wars planned, prepared, initiated, and waged. A. The wars referred to in the statement of offense in this count 2 of the indictment and the dates of their initiation were the following. Against Poland, 1st September 1939. Against the United Kingdom and France, 3rd September 1939. Against Denmark and Norway, 9th April 1940. Against Belgium, the Netherlands, and Luxembourg, 10th May 1940. Against Yugoslavia and Greece, 6th April 1941. Against the USSR, 22nd June 1941. And against the United States of America, 11th December 1941. B. Reference is hereby made to count 1 of the indictment for the allegations charging that these wars were wars of aggression on the part of the defendants.
Up next, the French and the Russians list their charges against the defendants. Walter Cronkite had some interesting observations on the Russians during the Nuremberg trial.
The Russians at the press camp, where we all lived together, were mostly very friendly. There was some standoffishness by some of them, but we got along with others very well. There was a consciousness, certainly, that the Russians were different, that they weren't wholeheartedly in our camp, that they were holding off a bit.
Count 3 of the indictment was handled by France and the Soviet Union. It charged the defendants with war crimes. These were acts which violated traditional concepts of the law of war, such as the use of slave labor, the bombing of civilian populations, the infamous reprisal order, saying that 50 Soviet hostages should be shot for every German killed by the enemy. These violations of international law were more clearly rooted in precedent than the crimes charged in the other counts, since they stemmed in part from The Hague and the Geneva Conventions. The prosecutor that we're going to see is Pierre Mounier, and he begins after tribunal president Sir Geoffrey Lawrence notes that Ernst Kaltenbrunner was ill and that the trial should proceed without him. Kaltenbrunner, whose responsibilities included the Gestapo and the death camps, was hospitalized 3 days before the trial began from a minor cerebral hemorrhage. He returned to the dock on December 10th.
The tribunal understands that the defendant, Ernst Kaltenbrunner, is temporarily ill. The trial will continue in his absence. I call upon the Chief Prosecutor for the Provisional Republic of France.
Chef d'accusation numéro 3.
All of the defendants committed war crimes between September 1, 1939 and May 8, 1945 in Germany and in all those countries and territories occupied by the German armed forces since September 1, 1939, and in Austria, Czechoslovakia, and Italy, and on the defendants acting in concert with others, formulated and executed a common plan or conspiracy to commit war crimes as defined in Article 6b of the Charter. This plan involved, among other things, the practice of total war, including methods of combat and of military occupation in direct conflict with the laws and customs of war, and the perpetration of crimes committed on the field of battle during encounters with enemy armies against prisoners of war and in occupied territories against the civilian population of such territories. Throughout the period of their occupation of territories overrun by their armed forces, the defendants, for the purpose of systematically terrorizing the inhabitants, ill-treated civilians, imprisoned them without legal process, tortured and murdered them. The murders and ill-treatment were carried out by diverse means such as shooting, hanging, gassing, starvation, gross overcrowding, systematic undernutrition, systematic imposition of labor tasks beyond the strength of those ordered to carry them out, inadequate provision of surgical and medical services, kickings, beatings, brutality, and torture of all kinds, including the use of hot irons and pulling out of fingernails, and the performance of experiments by means of operations and otherwise on living human subjects.
Would you read a little bit slower? Yes, sir.
Such crimes and ill-treatment are contrary to international conventions, in particular to Article 46 of the Hague Regulations 1907, the laws and customs of war, the general principles of criminal law as derived from the criminal laws of all civilized nations, the internal penal laws of the countries in which such crimes were committed, and to Article 6b of the Charter.
Soviet prosecutor J.A. Azol then moved to count 4, crimes against humanity. This dealt with the death camps, concentration camps, and the killing rampages in the East. This count, like count 3, was assigned to the French and the Soviets, who divided the responsibility along east-west lines. The legacy of the Nuremberg Trial is viewed as emanating from this charge, which revealed unspeakable acts of persecution, suppression, and eventual extermination of millions of people. For the Jews, this is the evidence of the Holocaust, the genocide of some 6 million.
I will now call upon the chief prosecutor for the Soviet Union.
All the defendants, acting in concert with others, formulated and executed a common plan or conspiracy to commit war crimes as defined in Article 6b of the Charter. This plan involved, among other things, the practice of total war, including methods of combat and of military occupation in direct conflict with the laws and customs of war, and the commission of crimes perpetrated on the field of battle during encounters with enemy armies and against prisoners of war, and in occupied territories against the civilian population of such territories. The prosecution will rely upon the facts pleaded under count 3 as also constituting crimes against humanity. A, murder, extermination, enslavement, deportation, and other inhumane acts committed against civilian populations before and during the war. For the purposes set out above, the defendants adopted a policy of persecution, repression, and extermination of all civilians in Germany who were, or who were believed to, or who were believed likely to become hostile to the Nazi government and the common plan or conspiracy described in count 1. They imprisoned such persons without judicial process, holding them in protective custody and concentration camps, and subjected them to persecution, degradation, despoilment, enslavement, torture, and murder.
Alan Dershowitz, war crimes, crimes against humanity, are they different? Are they the same?
They're different. The line isn't absolutely sharp, but crimes against humanity is what is really unique about this trial, an attempt to commit genocide against an entire people, bringing people in from Greece, from Italy, from other places to kill them in central execution camps was what was so unique, crimes against humanity. War crimes had been committed for generations, and war crimes, of course, the Nazis thought we committed some against them. The bombing of Dresden, some people think the bombing of at least Nagasaki, if not Hiroshima, may have constituted a war crime. Those are crimes growing out of war, but in violation of the rules of war. Now, when you get civilian victims, the line between crimes against humanity and war crimes is not always a sharp one, but it ought to be kept in mind, because what was so unique about what the Nazis did were the crimes against humanity, and that's the real legacy of Nuremberg.
And what Alan Dershowitz points out is perhaps a defense. You did it, so we did it. That defense was not permitted at the Nuremberg trials. When we return, the defendants speak.
Rudolf Hess.
No.
As they answer the charges against them. The men in the dock were called upon to plead guilty or not guilty. Hermann Goering attempts to make a statement, which is in keeping with his conduct during the trial as he tries to continue his role as a wartime leader, second only to Hitler. His words, translated in 3 other languages, are the same as those used by Adolf Eichmann when he pleaded not guilty in Jerusalem in 1961.
I will now call upon the defendants
to plead guilty or not guilty to the charges against them. They will proceed in turn to a point in the dock opposite to the microphone. Hermann Wilhelm Göring.
Before I answer the question of the tribunal whether or not I am guilty,
I informed the court that defendants were not entitled to make a statement. You must plead guilty or not guilty.
I declare myself, in the sense of the indictment, not guilty.
Rudolf Hess.
No.
That will be entered as a plea of not guilty. If there is any disturbance in court, those who make it will have to leave the court. Joachim von Ribbentrop.
I declare myself, in the sense of the indictment, not guilty.
Wilhelm Keitel.
I declare myself not guilty.
In the absence of Ernst Kaltenbrunner, the trial will proceed against him, but he will have an opportunity of pleading when he is sufficiently well to be brought back into court. Alfred Rosenberg.
I declare myself, in the sense of the indictment, not guilty.
Hans Frank.
I declare myself not guilty.
Wilhelm Frick.
Nicht schuldig.
Not guilty.
Julius Streicher.
Nicht schuldig.
Not guilty.
Walter Funk.
Ich bekenne mich nicht als schuldig.
I declare myself not guilty.
Hjalmar Schacht.
I am not guilty in any respect.
Karl Dönitz.
Schuldig.
Not guilty.
Erich Raeder.
Ich bekenne mich.
I declare myself not guilty.
Baldur von Schirach.
Ich bekenne mich.
I declare myself, in the sense of the indictment, not guilty.
Fritz Sarko.
I declare myself, in the sense of the indictment, before God and the world, and particularly before my people, not guilty.
Alfred Jodl.
Nicht schuldig.
Not guilty. For what I have done or had to do, I have a pure conscience before God, before history, and my people.
Franz von Papen.
I declare myself in no way guilty.
Arthur Seyss-Inquart.
I declare myself not guilty.
Albert Speer.
Nicht schuldig.
Not guilty.
Konstantin von Neurath.
I answer the question in the negative.
Hans Fritzsche.
As regards this indictment, not guilty.
Alan Dershowitz, they all say in one form or another not guilty. They were looking many at 4 counts, including waging aggressive war as well as crimes against humanity. What effect did that have?
Well, it was a terrible decision to charge both with aggressive war and crimes against humanity, because aggressive warfare has been waged from the beginning of time. Every one of the judging countries had waged aggressive war at one point in its history, particularly the Soviet Union, which invaded Poland essentially when the Germans did as well. The Bible sanctions aggressive war. We've had aggressive war from the beginning of time. There was nothing unique about aggressive war. And so it allowed some of the Nazis to assume the moral high ground, saying this was just victor's justice. Had they limited it to the unique aspects of what the Nazis did, namely the crimes against humanity, it would have had a much stronger moral basis. But the 4 nations would not have agreed. And I think the Soviets were insistent on making this into much more of a political trial than the United States was interested in. Also, American public opinion wasn't as interested in the Holocaust as they were in the aggressive war which had been waged against it, as the result of which it lost its own soldiers. So it was very much of a compromise.
Well, in fact, Justice Jackson, being the lead prosecutor, winds up saying that this is his thing. This waging aggressive war was the thing he wanted most to deal with. Fascinating. Well, we're going to take a break. We'll be right back with more of the Nuremberg trial, the opening statements after this. Coming up.
The common sense of mankind demands that law shall not stop with the punishment of petty crimes by little people.
Justice Robert Jackson delivers his historic opening statement to the tribunal, and we'll take our first look at the evidence that shocked the court and the world. Concentration camp film. All that and more in our coverage of the Nuremberg trial. Robert Jackson was on leave from his job as an Associate Justice of the United States Supreme Court. He was appointed as the lead United States prosecutor in Nuremberg by Harry Truman. Jackson didn't attend college and completed only 1 year of law school. He became an attorney by serving an apprenticeship. He served as both Solicitor General and Attorney General before going to the High Court. While other World War II allies originally wanted summary execution of Nazi war criminals, the United States pushed for a trial. Jackson hoped that the proceedings at Nuremberg would create new international law outlawing aggressive warfare. His opening statement ran for the better part of a day and is considered by many to be one of the great pieces of oratory. The excerpts we're showing you were taken from the 10-month-long trial. All of the trial was audiotaped, a portion was filmed. For those sections not filmed, we've used freeze frames of the film. Now, Justice Jackson's opening statement.
I will now call upon the Chief Prosecutor for the United States of America.
The privilege of opening the first trial in history for crimes against the peace of the world imposes a grave responsibility. The wrongs which we seek to condemn and punish have been so calculated, so malignant and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. That four great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. This tribunal, while it is novel and experimental, is not the product of abstract speculation, nor is it created to vindicate legalistic theories. This inquest represents the practical effort of four of the most mighty of nations, with the support of 15 more, to utilize international law to meet the greatest menace of our times, aggressive war. The common sense of mankind demands that law shall not stop with the punishment of petty crimes by little people. It must also reach men who possess themselves of great power and make deliberate and concerted use of it to set in motion evils which leave no home in the world untouched. It is a cause of that magnitude that the United Nations will lay before your honors. In the prisoner's dock sit 20-odd broken men, reproached by the humiliation of those they have led almost as bitterly as by the desolation of those they have attacked. Their personal capacity for evil is forever past. It is hard now to perceive in these men as captives the power which, as Nazi leaders, they once dominated most of the world and terrified most of it. Merely as individuals, their fate is of little consequence to the world. What makes this inquest significant is that these prisoners represent sinister influences that will lurk in the world long after their bodies have returned to dust. We will show them to be the living symbols of racial hatreds, terrorism, and of violence, and of the arrogance and cruelty of power.
This is merely a beginning of Justice Jackson, and he is eloquent in his presentation. And Alan Dershowitz, he talks about the idea of these four powers coming together to go and seek really the truth of what happened in Nazi Germany. Do you think it served that purpose, to seek the truth?
I think it did. I think this will make Holocaust denial impossible for any rational human beings for the remainder of time. We have documented proof that has been preserved through a court trial. Courts are usually not very good at being at searching for truth, though they always have to balance other values with a search for truth. But in this case, I think it preserved a documentary record that will be unique in history. When all of the participants are long gone, we will still have the Nuremberg tribunals. And it's interesting, the Holocaust deniers must delegitimate the Nuremberg tribunals, and they always try to. But they stand on their own as a very powerful historical account as well as legal account of the horrors of what occurred.
These four powers had to get together, do a lot of give and take to finally arrive at a system of judging these 22 odd men in the dock, really 21, because of Martin Bormann being tried in absentia.
Right.
And in that give and take, there was a mixture between the continental law and the Anglo-American law, and some of it pulled one way, some of it pulled the other. You're a student of that. How did that work?
Compromise. What it was we had to deal with the Soviet Union. That was primarily the compromise that had to be struck. France never should have been in this trial. Some of France's leaders should have been in the dock. They had no right to be judging Germany. So many Frenchmen were complicitous. They didn't fight. They surrendered and turned over their Jews for transport. So it was really the English who certainly deserved to be there, and the Russians, who by dint of their military victory had to be there. But of course, Russia being there, the Soviet Union being there, created a terrible dilemma for the United States. I mean, the Soviet Union had engaged in aggressive warfare. It had committed crimes against humanity in the Ukraine. It was plotting, as they were sitting at Nuremberg, discriminatory measures against Jews, which came into fruition only a year or two after the Nuremberg trials, and Stalin was planning to learn from Hitler and deport all of his Jews when he fortuitously died at the right time. So there was a large mix of hypocrisy, of realpolitik. It's both the end of the Second World War and the beginning of the Cold War, and you know, you can't separate law from politics, even in typical cases. Imagine when the world is watching nations putting another nation essentially on trial. Politics has to play. But, you know, Jackson did a marvelous job in acting as a lawyer and in trying to distill the legal principles from continental law, from Anglo-American law, and from international law, and for that he deserves great praise.
And we're going to watch much more of Justice Jackson. And after this break, more of his eloquent, passionate opening, an opinion shared by United States Prosecutor Telford Taylor.
Nobody in what we were doing had ever in my ability seen anything as good as his.
The crowd of excited Nazis was present at the opening of the official anti-Semitic campaign of April 1st, 1933. The fervor of many of the German people who supported Adolf Hitler, coupled with his absolute authority which had to be obeyed, permitted an atmosphere where incredible crimes could be committed by the Nazis. The Nazis, in their belief of being the master race and in their plan to dominate the world, invaded other countries and enslaved millions of people. Robert Jackson continues his opening statement on this subject.
These men stand for, we will patiently and temperately disclose. We will give you undeniable proofs of incredible events. The catalogue of crimes will omit nothing that could be conceived by a pathological pride, cruelty, and lust for power. These men created in Germany, under the Führer principle, a national socialist despotism equaled only in the dynasties of the ancient East. They took from the German people all those dignities and freedoms that we hold natural and inalienable rights in every human being. The people were compensated by inflaming and gratifying hatreds towards those who were marked as scapegoats. Against their opponents, including Jews, Catholics, and free labor, the Nazis directed such a campaign of arrogance and brutality and annihilation as the world has not witnessed since the pre-Christian era. They excited the German ambition to be a master race, which of course implies serfdom for others. They led their people on a mad gamble for domination. They diverted social energies and resources to the creation of what they thought to be an invincible war machine. They overran their neighbors. To sustain the master race in their war making, they enslaved millions of human beings. and brought them into Germany, where these hapless creatures now wander as displaced persons. At length, bestiality and bad faith reached such excess that they aroused the sleeping forces of imperiled civilization. Its united efforts have ground the German war machine to fragments. But the struggle has left Europe a liberated yet prostrate land where a demoralized society struggles to survive. These are the fruits of the sinister forces that sit with these defendants in the prisoner's dock. Injustice to the men and to the nations associated in this prosecution. I must remind you of certain difficulties which may leave their mark on this case. Never before in legal history has an effort been made to bring within the scope of a single litigation the developments of a decade, covering a whole continent, involving a score of nations, countless individuals, and innumerable events. Despite the magnitude of the task, the world has demanded immediate action. This demand has had to be met, though perhaps at the cost of finished craftsmanship.
Justice Jackson was assisted by many talented people, including Telford Taylor. Alan Dershowitz, you know him well. Tell us about him.
Telford is one of the great, great people of the 20th century, a man who replaced Justice Jackson as the chief prosecutor for the next level of trials, and devoted his life, he's still alive and hope remains alive and well for a long time, has devoted all of his life to the defense of human rights. He wrote a book on Vietnam and Nuremberg. He and I traveled to the Soviet Union twice and to Israel twice, using Nuremberg principles to try to free Soviet dissidents and refuseniks, and using Telford's close relationship with Roman Rudenko, who was one of the Russian prosecutors, who was then the Procurator General of the Soviet Union, and a man named Smirnov, who was one of the people involved in Nuremberg, who, when we went to the Soviet Union together, had become a justice of the Supreme Court of the Soviet Union. Telford has just been tireless in trying to use the Nuremberg principles in a sensible and productive way. And just on a personal note, he was my teacher and, you know, my role model. I've never been able to come close to what he's done, but I still aspire.
Well, thank you for that personal touch. After this break, we continue with Justice Jackson's opening statement, and remarkably enough, he intends to prove his case by the Germans' own documents. After the war, the Nuremberg trial began with all deliberate speed, a speed that was actually quite amazing, and as a result, Justice Jackson and his co-prosecutors, the people working for him, were gathering up documents one by one, batch by batch, in order to be ready. Justice Jackson had strong feelings that the documentary evidence that had been captured, often by some amazing detective work. The documents concerning the Luftwaffe were found in salt mines in Salzburg. Well, these documents came almost by the ton. Justice Jackson felt that documents were far more worthwhile than witnesses in this prosecution. As we return to his opening statement, we are at a segment where he is talking about some of the problems of rushing so fast to trial after a Second World War and how that might affect the legacy of Nuremberg.
In my country, established courts, following familiar procedures, applying well-thumbed precedents, dealing with the consequences of local and limited events, seldom commence a trial within a year of the event in litigation. Yet less than 8 months ago today, the courtroom in which you sit was an enemy fortress in the hands of the SS troops. Less than 8 months ago, nearly all of our witnesses and documents were in enemy hands. The law had not been codified. No procedures had been established. No tribunal was in existence. No usable courthouse stood here. None of the hundreds of tons of official German documents had been examined. No prosecuting staff had been assembled. Nearly all of the present defendants were at large, and the four prosecuting powers had not yet joined in common cause to try them. I should be the last to deny that this court, this case, may very well suffer from incomplete researches, and quite likely will not be the example of professional work which any of the prosecuting nations would normally wish to sponsor. It is, however, a completely adequate case to the judgment we shall ask you to render, and its fuller development we shall be obliged to leave to historians, because we have not had the time to examine all of the sources of evidence that might be available. Before I discuss particulars of the evidence we shall offer, some general considerations which may affect the credit of this trial in the eyes of the world should be candidly faced. There is a dramatic disparity between the circumstances of the accusers and of the accused that might discredit our work if we should falter in even minor matters in being fair and temperate. Unfortunately, the nature of these crimes is such that both prosecution and judgment must be by victor nations over vanquished foes. The worldwide scope of the aggressions carried out by these men has left but few real neutrals. Either the victors must judge the vanquished, or we must leave the defeated to judge themselves. After the First World War, we learned the futility of the latter course. The former high station of these defendants, the notoriety of their acts, and the adaptability of their conduct to provoke retaliation make it hard to distinguish between the demand for a just and measured retribution and the unthinking cry for vengeance which arises from the anguish of war. It is our task, so far as humanly possible, to draw the line between the two. We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. We must summon such detachment and intellectual integrity to our task that this trial will commend itself to posterity as fulfilling humanity's aspirations to do justice.
And much of that trial, as we said, was based on documentary evidence compiled with real precision by the Germans. Alan Dershowitz, a decision was made, particularly by Justice Jackson as the chief prosecutor. He said, "I want documents, not witnesses." That decision was opposed by some of his staff. What do you think of that call?
It was a brilliant decision. Witnesses are selective in their memories, can be self-serving, can be disputed 20, 30 years later. For history, and this trial was for history, documentation was crucial. The difference between the role of the historian and the role of the judge was blended together in a case like this. And the Germans were such precise record keepers. They didn't think they were doing anything wrong. The way in which they kept precise records of the railroad cars and the shipments of Jews and the numbers of teeth and the numbers of, you name it, they had records of it. The Zyklon gas, the canisters, made it impossible to deny what witnesses could have denied. Even today, 50 years later, the testimony of the few witnesses that did testify at the various Nuremberg trials are now disputed. People say, oh, well, they were hoping for leniency, they were trying to get something out of it. You can't dispute these documents. It was a brilliant decision. May not have played well with the press, because reading document after document can bore even a judge to death. This wasn't a jury trial. These were professional judges, and for professional judges, it was the right decision.
It's interesting. There's always an old adage in criminal trials that defense lawyers have used in talking to juries, where they talk about the fact that real evidence, that is, things you can touch, see, in this case read, real evidence doesn't lie. Only people do, as so said by Alan Dershowitz in another way just now. We're going to take a break, and as we go to the break, the question is, why Nuremberg as a selection for this site? We're going to hear from the chief British prosecutor.
I think largely for psychological reasons, that it had been the leading establishment of the Nazi parties. They were based essentially on Nuremberg. There was a courthouse there and all the facilities for a major trial.
Nuremberg was a very attractive city. The houses, is probably still true in that part of Europe, typically 6-story multiple dwellings, not any higher than that, but built of good materials. I mean, not wood, not brick, but nicely cut masonry. A wealthy city. And the bombing had been so heavy that nothing was left standing but the shells of these 6-story buildings.
That was the clerk to Judge Francis Biddle, that's Herbert Wexler, reflecting on the selection of Nuremberg as the trial venue. And back during the proceedings, Jackson advises the court in his opening statement about more of this meticulous record-keeping of the Germans, which will prove the case against the men in the dock. In addition to documents, there's captured German film, and there are films of the United States and the Soviet Union as well, which reveal horrors that boggle the mind. The question: who should be held accountable?
If these men are the first war leaders of a defeated nation to be prosecuted in the name of the law, they are also the first to be given a chance to plead for their lives in the name of the law. Realistically, the charter of this tribunal, which gives them a hearing, is also the source of their only hope. It may be that these men of troubled conscience, whose only wish is that the world forget them, do not regard a trial as a favor. But they do have a fair opportunity to defend themselves, represented here by able counsel who have shown their capacity to handle their case with credit and who've acted with courage. And these men now enjoy a favor which, when in power, they rarely extended even to their fellow countrymen. Despite the fact that public opinion may already condemn their acts, we agree here that they must be given a presumption of innocence, and we accept the burden of proving criminal acts and the responsibility of each of these defendants for their commission. We will not ask you to convict these men on the testimony of their foes. There is no count in the indictment that cannot be proved by books and records. The Germans were always meticulous record keepers, and these defendants had their share of the Teutonic passion for thoroughness in putting things on paper. Nor were they without vanity. They arranged frequently to be photographed in action. We will show you their own films. You will see their own conduct and hear their own voices as these defendants reenact for you some of the events in the course of the conspiracy. The German people should know by now that the people of the United States hold them in no fear and in no hate. The Nazi nightmare has given the German name a new and sinister significance throughout the world, which will retard Germany a century. The German, no less than the non-German world, has accounts to settle with these defendants. It is my purpose to open the case, particularly under count 1 of the indictment, and to deal with the common plan or conspiracy to achieve ends possible only by resort to crimes against peace, war crimes, and crimes against humanity. The case as presented by the United States will be concerned with the brains and the authority back of all the crimes. These defendants were men of a station and a rank which does not soil its hands with blood. They were men who know how to use lesser folk as tools. We want to reach the planners and designers, the inciters and leaders, without whose evil architecture the world would not have been for so long scourged with the violence and lawlessness and racked with the agonies and convulsions of this terrible war.
A question that has often come up out of this tribunal, Alan Dershowitz, is the whole issue of, wasn't this all ex post facto lawyering? And why don't you define what that is as you give us your answer?
Well, the United States Constitution has a provision, actually it's not even in the Bill of Rights, it's in the body of the Constitution, against punishing somebody for a crime that was not on the books at the time the person committed that crime. Interestingly enough, right now in Israel, when they're thinking about bringing to trial perhaps some of the conspirators or rabbis who may have incited, they're facing a similar problem of ex post facto. I don't want to make any analogies, obviously. But here in this case, if it had been judged by domestic American law, by the United States Constitution, it probably would not have passed the test. It would have been ex post facto. But we're dealing with international common law, which by its very nature evolves. And what the lawyers and judges try to do is pick out of the domestic laws of the various countries, the various international common law that had developed over time, a series of principles, and announce that they really were in effect. They may not have been written down in any one place, but they were in effect at the time, and these people were on notice. Not that they would be prosecuted, but that what they did was against the law.
It's interesting because, as you say, that's one of the reasons that they didn't call what they were using to create the tribunal and go forward. They didn't call it a statute. They called it a charter, and part of the reason is, as Alan Dershowitz explains, to avoid this whole issue of ex post facto. We're taking a break. When we return, more of the Nuremberg trial, including photographs of the Warsaw Ghetto.
Judge Lawrence was one of the most amazing people I ever hoped to see on the bench or off the bench. He had a firmness about him, and yet he didn't sound, nor did he behave in an arbitrary fashion. And he seemed to listen and remember great amounts of detail as to what had gone on before and what had been said. And when he was wrong, he didn't hesitate to admit it. I think that between him and Sir David Maxwell-Fyfe and Justice Jackson, you have the three big characters of the trial.
That was U.S. Prosecutor Drexel Sprecher commenting on those that carried these proceedings. One of those men, Robert Jackson, uses his opening statement to persuade the court to his point of view before the formal introduction of evidence during the trial. He looks to the evidence which is remembered so well from Nuremberg, the crimes perpetrated against the Jews. He uses documents which call for a final solution to the Jewish question, the ultimate extermination of an entire race of people. He shows pictures which by now have become all too familiar to those who have studied the Holocaust. But it was all true. Evidence of the destruction of the Warsaw Ghetto shocked the world.
The most savage and numerous crimes committed by the Nazis were those against the Jews. It is our purpose to show a plan and a design to which all Nazis were fanatically committed to annihilate all Jewish people. These crimes were organized and promoted by the party leadership, executed and protected by the Nazi officials, as we shall convince you by written orders of the secret state police itself. Persecution of the Jews was a continuous and deliberate policy. It was a policy directed against other nations as well as against the Jews themselves. Anti-Semitism was promoted to divide and embitter the democratic peoples and to soften their resistance to Nazi aggression. The conspiracy or common plan to exterminate the Jew was so methodically and thoroughly pursued that despite German defeat and Nazi prostration, this Nazi aim largely has succeeded. Only remnants of the European Jewish population remain in Germany, in the countries which Germany occupied, and in those which were her satellites or collaborators. Of the 9,600,000 Jews who lived in Nazi-dominated Europe, 60% are authoritatively estimated to have perished. 5,700,000 Jews are missing from the countries in which they formerly lived, and over 4.5 million cannot be accounted for by the normal death rate nor by immigration, nor are they included among displaced persons. History does not record a crime ever perpetrated against so many victims or carried out with such calculated cruelty. You will have difficulty, as I have, to look into the faces of these defendants and believe that in this 20th century, human beings could inflict such sufferings as will be proved here on their own countrymen as well as upon so-called inferior enemies. Defendant Hans Frank, a lawyer by profession, I blush to say, summarized in his diary in 1944 the Nazi policy thus, and I quote, "The Jews as a race are a race which has to be eliminated. Whenever we catch one, it is his end." I shall not dwell on this subject longer than to quote one more sickening document which evidences the planned and systematic character of these Jewish persecutions. I hold an original report, written with Teutonic thoroughness as to detail, illustrated with photographs, to authenticate its almost incredible text, and beautifully bound in leather, with loving care bestowed on a proud work. It is the original report of the SS Brigade General Stroop, in charge of the destruction of the Warsaw Ghetto, and Hans Frank was Governor General of Poland. Its title page carries this inscription: "The Jewish ghetto in Warsaw no longer exists." I shall ask your honors to examine with care the photographs with which this document abounds, showing the destruction of this ghetto, showing the people driven before the flames, with the title, "Jews and Bandits," women and children and old men, not a man of fighting age in the picture except the German soldiers. The masses lined up against the wall for execution. The picture to illustrate the text showing that they jumped from the windows during the flames to escape. Now let us read what General Stroop says he did. "The resistance put up by the Jews and bandits could only be suppressed by energetic action of our troops day and night. The Reichsfuhrer SS ordered, therefore, on the 23rd of April, 1943, the cleaning out of the ghetto with utter ruthlessness and merciless tenacity. I therefore decided to destroy and burn down the entire ghetto without regard to the armament factories. These factories were systematically dismantled and then burned. The Jews usually left their hideouts, but frequently remained in the burning buildings and jumped out of the windows only when the heat became unbearable. This action eliminated, says the SS commander, I quote, a proved total of 56,065 Jews. To that, he says, we have to add the number of those killed through blasting, fire, and so forth, which cannot be counted. We charge that all of the atrocities against Jews were the manifestation and culmination of the Nazi plan to which every defendant in this box was a party.
Chilling, to say the least. Alan Dershowitz, that picture of the young boy with his hands up, really one of the most famous pictures of the Holocaust.
The most amazing thing is it's a story of such redemption and survival. That young man was one of the very, very few people who managed to survive the Holocaust, because, you know, the reason why there was resistance, obviously, at the Warsaw Ghetto was by that time the Jews knew that their fate had been sealed, that they were being shipped directly from Warsaw, mostly to Treblinka. Treblinka was not a work camp. It was just a place where the train would come and people were put right from the train into the killing chambers, the gas chambers, and then the crematorium. And when you think about Warsaw, you have to think of it like New York City. Warsaw was like New York. 1/3 of its population was Jewish, professors, intellectuals, ordinary folks, and that 1/3 of the population was rounded up into a very small ghetto. Many died just as a result of the horrors. Some managed to sneak out through cemetery. I've been there. I've seen the sewer system that they used. But the vast, vast majority, 95%, ended up being murdered one way or another.
In this particular case where people are being punished for their acts as war criminals, one of the defendants is someone who is not being punished for these acts and acts of sending people to camps and acts of violence by his own hand, but Julius Streicher was being tried and potentially punished for using his words, his mouth. What was that about, and why does that not sit so well with many people?
Well, it was the most extreme form of hate speech imaginable. He was the megaphone of the Nazi Party. He ran the newspapers, Der Stürmer. He was the one who created those pictures of the Jews with the hook noses and the anti-Semitic stereotypes. He dehumanized the Jews. He made it possible for others to kill Jews without thinking that they were killing human beings. He used the analogies over and over again of vermin and insects. And if there was ever a case where speech killed, this was that. Nonetheless, we do sit uncomfortably with the idea of executing somebody for, quote, mere speech. This is an issue that goes back from the beginning of time, will be with us to the end of time. We will never resolve where to draw that line. When does speech become a trigger for action? Oliver Wendell Holmes talked about shouting fire in the theater. This is a more compelling case than that even, because this was, as Justice Jackson eventually put it, the cheerleader whooping up the crowd and making them do the things that eventually they did. Yet there are still some who are uncomfortable with trying a man like that, along with the hands-on perpetrators of the Holocaust.
And so the perpetrators of the Holocaust, and as Alan Dershowitz says, the man with the figurative megaphone, and you wind up with the pictures of the Warsaw Ghetto. We're taking a commercial break. When we return, more of the Nuremberg Trial. The prosecution begins its case, including the concentration camps. Stay with us. Still ahead.
They propose to accomplish these objectives by any means found opportune.
The Americans begin their case, and the court witnesses vivid evidence of Nazi atrocities. Coming up, an odd look at the Nuremberg Trial.